Welcome, welcome, welcome. I'm Ginny Hallam of Halborns, and you're listening to our 10 Minutes With sessions. Halborns are part of the brilliant Empowering People group who supports with tech-enabled people solutions. And part of our support are these 10 Minutes With sessions. Now, I've got a confession to make. We've called this 10 Minutes With, but there is so much new law to talk through. We need a bit more time. So really, the title of this session should be around 30 minutes with. It needs work, I know. But with new people laws coming out thick and fast, Stefan Mars, who is head of the legal team, is going to take around 30 minutes to chat through all of the new legislation that's coming into place. Now, he has an amazing ability to turn the complex into the practical, and Stefan's going to give you a clear and concise summary of all the changes in new people laws that you need to know about and when they're going to take effect. Hi, Stefan.
Hello.
There's a lot for us to get through today. I think you're going to approach the new laws in the order that are coming into force. So shall we get cracking?
Let's do it. So I'm looking forward to taking everyone through the new legislation. I've put myself in the people's team's shoes, which is why I'm talking about each new piece of legislation in the order it comes in to help prioritise actions. I've also included at the end of each new piece of law some practical tips on how to deal with the new law. And don't worry about taking lots of notes. If you contact me at the end of the session, I can give you a 2-page summary of all of the new laws and their practical impact.
Amazing. Thank you so much. We're really looking forward to this session. I think the first change that you're going to cover is around the rules on spent criminal convictions. We're not trying to turn everyone into criminal lawyers here. We just want to understand how those changes are going to have an impact on employers.
That's right. So the first new piece of legislation I'm going to mention is the Police, Crime, Sentencing and Courts Act 2022, which makes some changes to the rules around criminal convictions becoming spent, and came into force on the 28th of October 2023. So when a conviction becomes spent, it means that job applicants don't have to tell you about it, and the conviction won't show up on a basic criminal records DBS check. Now, under these new rules, most sentences become spent after a shorter time. Previously, prison sentences of over 4 years never became spent, so that job applicants would always have to tell you about them if you asked. But under the new rules, these longer sentences will now become spent after 7 years, although there are some exceptions for serious violent, sexual and terrorism offences. For example, a conviction for high-value theft would often result in a sentence of over 4 years in prison. Now, under the previous regime, the conviction would never have become spent, so a job applicant would always need to declare it. But under these new rules, it would become spent after 7 years, and they'd be free to tell you they didn't have a criminal record, despite the previous conviction. We therefore recommend reviewing your recruitment forms, systems, and any relevant policies to ensure they're consistent with the new shorter timescales for criminal convictions to become spent. And also consider running background checks for key appointments, just to make sure there are no nasty surprises further down the track.
So the next change that's coming into force is to do with holiday pay, isn't it? We've got changes coming out. Can you talk us through what they look like?
Sure. So the second piece of legislation I'd like to mention is the catchily named Employment Rights Amendment, Revocation and Transitional Provision Regulations 2023. Trips off.
Who thought of that? Yeah.
So these regulations are still in draft form, but they're likely to come into force on the 1st of January 2024. And the most important changes relate to holiday pay. Firstly, for workers working irregular hours or for only part of the year, such as term time only. So until recently, most employers were paying holiday pay for these workers based on a rolled up holiday pay system, based on 12.0% of the number of hours that they worked. So if they worked for 10 hours, they'd accrue 1.207 hours of holiday. It was a fairly simple method and easy to work out. But then in August 2022, the Supreme Court, in a case called Harper Trust and Brazel, ruled that this practice didn't comply with the working time regulations and couldn't be allowed. Instead, a much more complicated calculation had to be followed that allowed these workers the equivalent of 5.6 weeks of holiday a year. In some cases, this meant that irregular hours workers were proportionately better off than year-round or regular hours workers. So the good news for employers is that these new regulations will allow you to return to the previous 12.07% of calculating holiday pay for irregular workers from the date that the new regulations apply, which should considerably simplify holiday pay calculations for these workers. So keep an eye out for our updates to confirm that the change will definitely be happening from the 1st of January, and then make changes required to your holiday pay calculation systems. We've also created a diagnostic tool for rolled up holiday pay, which will help you to navigate these tricky issues. So the second thing the regulations provide for is clarifying that holiday pay for all employees and workers needs to be based on average pay actually received, to include things like commission and overtime payments. This sets out in UK regulations for the first time a principle that had been developed by the European Court of Justice in various different decisions. So the idea is that if you don't get the same pay while you're on holiday than you do when you're working, you're not likely to take all of your holiday allowance. Some businesses were already paying enhanced holiday pay based on the earlier European Court decisions. However, for those businesses that don't currently include these additional elements of pay and holiday pay, this will obviously make holiday pay more expensive than it currently is. Let us know if you'd like to chat through how you go about introducing any change to your holiday pay system.
I think of all of the changes that you're going to talk about today, these are actually the most complex. So that diagnostic tool will be super helpful to help our audience today to piece through how these new laws are going to affect them and their employees. So yeah, thank you for pulling that together. And then, so moving away from holiday pay, we've then got changes, haven't we, in terms of family-related redundancy protections?
That's right. Yeah. So the next piece of legislation is the Protection from Redundancy, Pregnancy and Family Leave Act 2023. This is likely to come in April 2024. So it provides additional protection for pregnant women and those taking maternity, shared parental or adoption leave. All of the statistics show that women are most likely to be made redundant before, during or after maternity leave than any other time during their employment. And the aim of this legislation is to provide additional protection to address this issue. So currently, the protection is that a woman on maternity leave has priority for suitable alternative roles where another vacancy exists if they're selected for redundancy. So they don't get priority during the redundancy process itself. They don't get preference in terms of the scoring. You can still make a woman on maternity leave redundant in appropriate circumstances. They just get priority in terms of any suitable alternative roles elsewhere within the business. But at the moment, this protection only applies during the actual period of maternity leave. There's no protection before they go on maternity leave or once the employee has returned to work. And what these regulations do, or what this act does, is to extend that period of protection. So it's going to start from the moment the employee informs their employer of their pregnancy until 6 months after they return from maternity leave. So the window will be considerably expanded. And it also, for the first time, includes parents returning from adoption leave or shared parental leave. We need to await the detail of the regulations that are going to follow the Act to see how it will work in these cases. Now, given these new rights will apply to some men taking shared parental leave and adoption leave, employers will have to get used to these priority rights applying to men for the first time. It's not clear exactly how the rights will work where more than one employee is entitled to priority treatment, and there are only one or a limited number of suitable alternative roles. It's likely that employers will have to come up with a tiebreaker criteria or set of criteria to select who the successful candidate is. You'll also want to train those implementing redundancy processes on the new rules and update any applicable policies.
Thank you. And in respect of that training, I know that's something that you can offer, or I'm sure we can support with some of those training materials if that's the preference moving forwards. Again, a really important piece of new legislation with a really important reason for its implementation. So still connected to care and to families, we've got a new day one right, so first day of employment right for carers leave. That's
right. So it's the Carers Leave Act 2023. So this is a new right for carers to 1 week of unpaid leave per year. And as you say, it will be a day one right, which means they'll be able to take this leave from the first day of their employment. Again, likely introduction date, April 2024. And it applies to carers. So carers are defined as someone who is providing care for someone with a health condition lasting at least 3 months, who is disabled or who needs care as a result of old age. It includes those caring for a spouse, civil partner, child, parent, or person who lives in the same house. There have been some concerns from clients that I've been speaking to about these new rights, that they could be possibly open to abuse, given that there's no document that proves you're a carer. We're certainly going to await the detail in terms of the regulations, but it's likely that you'll be able to get the carer to sign a form, a sort of self-certification form, setting out why they're entitled to the leave. There's not going to be any need to evidence from the carer what the leave is for and whether it has been used for the purpose of care responsibility. Again, we await the detail in the regulations to be published, but it's likely that you'll be able to take the leave, the carer will be able to take the leave as either full days or half days, or potentially longer periods of up to a week per year. And again, from an employer point of view, you'll probably be able to tell the employee that they'll have to delay taking the leave if it would cause disruption to your business, but we await the detail in terms of how those provisions are going to work. And in common with other employment rights, there'll be protection for the employee if they're dismissed or they suffer any detriment as a result of taking time off under these care leave provisions. So in terms of practical suggestions, you'll want to create a system on your employee systems in terms of being able to track the number of days taken under these care leave provisions. You'll want to think about introducing a self-certification form for employees to complete, and you'll want to train your managers on the new rights. You'll also need to update your policies to include this right, of course. And for clients of Halborns who already use our Intelligent Employment Service, we'll be introducing a carers leave policy without charge.
Amazing. Thank you so much for thinking through the practical elements, because of course it's all well and good that we know the theory, but our audience are going to have to implement it practically. So invaluable. And there's been lots of chatter around flexible working requests being a day one right moving forwards, but that's now not happening, is it? So what's changing as far as flexible working is concerned?
That's right. So this is the the Employment Relations Flexible Working Act 2023. So the background to this is that these changes have been trialled for a long time by the government, and obviously COVID and lockdown has only increased the appetite amongst employees for flexible working. The idea of these provisions is to drive participation in the workforce of currently underrepresented groups like carers, the disabled, those with young children, etc. In terms of introduction date for this act, we're expecting this to come in the summer of 2024. So in terms of the main changes, previously you could only make one request for flexible working a year, but that's going to be changing to two. The timescale for the employer to respond to an application for flexible working, including any appeal, is going to be reduced from 3 months to 2. And there's going to be a new requirement to consult with employees before any decision to reject a flexible working request is taken. The vast majority of employers that I speak to consult with employees about flexible working requests anyway, but now there's going to be a new duty enshrined in the legislation. Previously, an employee would have to set out a business case in support of their request for flexible working, but that's no longer going to be required. But you can still discuss these sorts of issues with your employees before making a decision on whether to accept or reject a request. The good news from an employer point of view is that the current 8 statutory grounds for refusing a flexible working request will continue to apply. So the grounds aren't changing, things like cost, detrimental effect on customer service, etc. And yes, as you mentioned, there's going to be no change in the service qualification requirement to make a request. All the way through the passage of the bill, it was trailed as a day one right, but actually that's not changing. So it's still going to be 26 weeks service that you're going to need before you can make any applications for, or any formal applications for flexible working. We're also expecting a new ACAS code of practice on handling requests for flexible working, which hopefully will provide some additional detail and guidance. So the practical takeaway in terms of these provisions, if you want to reject a request for flexible working, make sure that you're doing so based on one of the 8 statutory grounds that I've mentioned. If you want to reject a request from a woman returning from maternity leave, seeking a request to return part-time, we definitely suggest you take further legal advice before responding to that request, as there's an additional right to bring an indirect sexual discrimination claim in these circumstances. You'll also need to update your policies with these changes at the appropriate time and also train your teams. And then there's the documents that are required to deal with the request. These will all need amending too. Clients using our Intelligent Employment Service will receive these updates without charge, and we'll let you know when they've been uploaded to our platform.
Lots to do, isn't there? It'd be good to know when we've got kind of solid dates on these. Obviously, we know they're coming in next year, but it'd be great to have an actual date so that people can then very much work towards them. And in a similar vein to flexible working requests, we've got a right to request more predictable working patterns. So that's a new piece of legislation that's coming in, isn't it? Can you tell us more about that?
Yeah, that's brand new. So it's the Workers' Predictable Terms and Conditions Act 2023. Introduction date, we do have a definite date for this one, September 2024. So the background to this is the gig economy, basically. So Uber and the like is under scrutiny as it provides, said to provide one-sided flexibility. And it potentially affects a very significant number of individuals. Apparently, there are 1.03 million people in the UK reported to be working on zero-hour contracts. And it's going to introduce a new right for these individuals to make a formal application after 26 weeks working in that role to change their working pattern to predictable hours. So it's similar to a flexible working application format. The idea is if you're currently on a 0 hours contract, for example, it's very difficult to get a mortgage, and you might be working a consistent number of hours, and you might ask your employer, please can I have a 30-hour-a-week guaranteed hours contract? And then there's a process to follow under these regulations to make that request. It's a right to make the request, but not obviously a right to automatically have it granted. But crucially, as well as those on 0 hours contracts, it's also going to apply to those on fixed term contracts of less than a year and agency workers. So an agency worker will have the right to request a contract of employment with set hours from the hirer for the first time. So it's not just a right to apply to the temporary work agency for predictable hours, but they're actually going to have a right to apply to the hirer for a contract of employment for predictable hours. So in common with the flexible working provisions, there's going to be a right to refuse for employers on 7 specific grounds, including additional costs and insufficient work at the time the employee wants to work. Workers will also be entitled to make up to 2 predictable working requests per year. And ACAS will be producing a new code of practice on how to deal with these requests, which is expected to be published early in 2024. Once the regulations and the code of practice are published, you want to consider introducing a right to request predictable hours policy, as well as updating and training your managers on dealing with the requests under the new provisions. We'll be adding the new policy without charge to our intelligent employment platform.
Fantastic. Lots of tongue twisters in this, aren't there? Okay, so now for something completely different, sexual harassment and some changes around that legislation. We're all used to dealing with sexual harassment legislation. It's been in for many years, but there's going to be further obligations on employers to prevent sexual harassment. Am I right in saying that?
That's right, yes. So we have the Worker Protection Amendment of Equality Act 2010 Act 2023, and it's going to make a significant change to the law on employers' obligations to protect employees from sexual harassment. Again, we've got a definite introduction date for this piece of legislation. That's October 2024. And it's a new duty on employers to take reasonable steps to prevent sexual harassment of your employees at work, i.e. unwanted conduct of a sexual nature. Actually, a slightly watered down version of the original proposals, which were going to require employers to take all reasonable steps, the word all is being dropped. It also originally contained a provision to make employers liable for harassment from third parties, such as clients and members of the public. This was dropped before the Act became law, but still a significant change in terms of an additional duty on employers. So it's not clear at this stage exactly what will be required to comply with the new duty. It's likely, though, to include things like having robust policies and procedures in place and taking action where those policies are breached, and also training your staff on what is and what isn't acceptable. There will also be consequences for the employer where the duty is breached, and the employee successfully brings us an employment tribunal claim. And in those circumstances, compensation will be increased by up to 25%. The Equality and Human Rights Commission will be updating its technical guidance on sexual harassment to clearly set out the steps employers will be required to take to comply with the new duty. So in terms of practical takeaways that we'd suggest, we'd recommend rolling out equality and diversity and anti-harassment training to your workforce as soon as possible in order to get your business ready for the new duty once it kicks in. But in order to be effective, it has to be in-depth and repeated. A recent case held that the employer's defence to a discrimination claim failed because the training wasn't meaningful and repeated. You'll also want to ensure that you can track who has received the training so you can evidence to a tribunal, if you need to, that you have taken those reasonable steps.
I think everyone's going to be doing a lot of training next year, don't you? Okay, so last but very much not least, another family right, and a really important change for those whose babies may require neonatal care. Can you talk us through the details as to what this new piece of legislation is going to cover?
Sure. So this is the Neonatal Care Leave and Pay Act 2023. So this one's coming into force in April 2025. So you've got plenty of time to prepare. So the purpose of this legislation is to allow additional time off for parents to spend with their baby where the baby is born prematurely or sick during the early period of their life. And the hope is that this will allow some peace of mind to parents in this clearly very difficult situation without eating into their maternity and maternity leave entitlements. So it applies where the baby needs hospital care for at least 7 days within the first 28 days of their life. And it applies to the parent of the baby, a partner married to the baby's parent, or an individual who has responsibility for bringing up the child. So this is a day one right, and it will apply from the first day of employment in terms of the leave, but the pay element of it requires at least 26 weeks service. And in terms of what it actually entails, it's the right to take up to 12 weeks additional neonatal care leave on top of the current maternity and paternity leave entitlements. And it will mirror the length of time that the baby spends in hospital. And the way it will work in practice is that the neonatal care leave will be added on to the end of either maternity leave or paternity leave. So we're thinking it's unlikely to be significantly disruptive to the business if it's the mother that's taking neonatal care leave on the basis that you probably be expecting her to take at least some maternity leave after the birth anyway. But it could be significantly more challenging for the business if the father or partner is required to take neonatal care leave, as instead of them being back to work after 2 weeks, you'd be potentially looking at up to 14 weeks of leave. So we suggest planning for what might happen in these circumstances. Practically, you'll either need to update existing policies or create a new one. Let us know if intelligent employment sounds of interest, as we'll be adding that policy to the platform without charge too. Finally, just for completeness, I should mention some new provisions that are literally hot off the press. So this is the Equality Act 2010 Amendment Regulations 2023 that have literally been published in the last couple of days. And these are all about adding into our domestic legislation from the 1st of January 2024, certain provisions of EU discrimination law that would otherwise have fallen away at the end of the year due to the Brexit provisions. So the good news is that these aren't changes as such because they are already part of the law that the courts and tribunals have been enforcing. And it covers things like discrimination by association. So, for example, being discriminated against because you have a disabled son, but you aren't disabled yourselves. And also making clear that discriminating against someone because they're breastfeeding amounts to sex discrimination. And then thirdly, allowing employees to bring equal pay claims by relying on a comparator from a different business where there's a single body responsible for setting their terms and conditions. We'll include the detail of these changes in the 2-page summary document that's available on request too.
There is so much new legislation, isn't there? Having had what seems to be years without much change, it's all coming out at once. What I found particularly helpful throughout the session is your practical suggestions. And although that's been brilliant, is there anything else that you can do to help people to implement what is some significant change to the way that we've been doing business?
Yes, we definitely can. We can support with a 2-page document which summarises the changes and also provides a checklist of the actions you'll need to take to ensure the organisation is ready for the new legislation. In addition, if you'd like us to train your teams on these changes, we can support with remote or in-person training. Just get in touch and we'll contact you to chat through any needs you have. Details will be on the screen. And if you like the sound of the diagnostic tool to help support how you make changes to rolled up holiday pay, just let me know and I'll send you over the detail. It's a super helpful tool to guide you through the possible changes you might be looking to make. We'll circulate information on how to access the diagnostic tool via our email updates. So if you're not currently subscribed to our updates, you can scan the QR code on the screen to sign up.
And our marketing team are going to kill me for suggesting this, but maybe a timeline might be really useful as well so that we can see exactly when the new laws are coming in. So we'll have a look at implementing that in addition. So as always, we will continue to keep our audience up to date through our emails with anything more we know about these laws, the precise dates that they're going to come into force. So if you don't currently get our updates, please do sign up using the QR code on the screen and we will keep you up to date. We take pride in being some of the first legal teams nationally to push out this information to clients. If you subscribe to our Intelligent Employment Service, all of the necessary documents on our platform will be updated as you'd expect and without further charge to reflect the changes that Stefan has discussed today. We'll notify you via email when those changes have been made so you know when to implement them. And if you'd like to know more about intelligent employment, the headlines of what the service includes are again on the screen. So please do get in touch if you would like to chat in more detail. Stefan, you have been amazing. Thank you so much for the hard work that you put into this training session. It is very much appreciated. I'm much clearer on the changes when they come in and what we need to do about them practically. Go and get yourself a cup of coffee. You deserve it. Please do keep us up to date with any changes to anything you've talked about, or once we know the dates of the new legislation, please do let us all know.
We certainly will. Thanks, Jenny.